Hello all, welcome back to Editorial Analysis and Answer Writing Practice at 9 p.m. Friends, if you are watching this video for the first time, then please watch my intro video given in the playlist to know how to participate in this answer writing program. It is open to all. According to National Judicial Data Grid, there are more than 5 plus crore pending cases in Indian judiciary. On this backdrop, Hindu Business Standard was carrying editorial analysis on this issue. So we will also discuss this topic from our UPSC exam point of view. When compared to European courts, in Indian courts, we see a considerable delay in solving the civil as well as criminal cases. For example, to arrive at a judgment for a criminal case, in Europe it will take roughly 6 months. In Indian judiciary, it takes roughly 30 months. Right? Similarly, uh, for solving the civil cases, particularly land disputes, on an average, it takes 20 years in India, and it is estimated that to resolve the all land-based disputes in India, it will take at least 324 years by the Indian judiciary to resolve to arrive at a final verdict. So why there is a huge delay? So one by one, we will try to understand. Number one, with respect to the number of judges available. See, as per the recommended standards, we need at least 50 judges for 1 million population. But in reality, we are having only 21 judges for 1 million population. And also with respect to the shortages, vacancies, the vacancies to be filled in the higher courts is roughly 30 percentage. Similarly, in the subordinate courts, we have a 22 percentage vacancy. And also, if you look at the support staff, the administrative staffs in the courts, we have a shortage of almost 26 percentage. There is infrastructural bottlenecks at the lower level, at subordinate courts, district courts, right? There is slow adoption of technology like artificial intelligence, information communication technology, particularly in the lower courts, right? And also today there is an increase in complicated cases coming to the courts because of the nature of commerce is getting changed. We see advent of lot of new age technologies. The complexity of the cases are getting increased, right? So if you look at the expertise of the judicial members, when compared to this increased new age complexity, that quality, that capacity of the judicial members is relatively less. Judicial members, judges, they have extraordinary experience in resolving the disputes, but what we are trying to convey here is we see a rise in complicated cases, right? To tackle that complicated technical cases, we need technical judicial members. So what we need is more technical tribunals to solve the cases. But the number of tribunals for tackling these new age cases is relatively less. So the burden falls on the regular higher court judiciary, and that becomes difficult. So to understand the complex nature, it takes a lot of time. That results in increase in pendency of cases. Right. And also, if you take the government cases, of all the cases, the government cases is the highest. Almost 50% of the cases, one of the litigant will be government. So government cases is also one of the reason for the high pendency in the Indian judiciary. Right. Now let us try to understand what are the efforts taken by the government as well as judiciary in overcoming this pendency of cases. See, a Department of Justice has come up with a centrally sponsored scheme to improve the infrastructure in the subordinate and district courts. Right, so they are from 1990s. They are taking regular efforts to strengthen the infrastructure. Similarly, we have e-court mission mode project, under which in the subordinate courts, government is trying to improve the information communication technology. Right, so basically, the under this program, the subordinate courts will be strengthened with this ICT advantage, ICT, information communication technologies. Right. Similarly, government has amended various laws to speed up the delivery of justice, to speed up the cases. Government has amended various laws. For example, Negotiable Instruments Amendment Act 2018, Specific Relief Amendment Act 2018. We have this Arbitration and Conciliation Act 2019. We have Criminal Law Amendment Act. Amendment Act 2018. So these laws are amended so that we are able to speed up in resolving the cases related to these laws. Right. Apart from that, government has also come up with a project called as the LIMS, LIMBS, Legal Information Management Briefing System. So under this LIMS initiative, 55 ministries are getting interconnected, and this project will effectively track almost 6 lakh plus pending government litigations. What is their status? right? All those will be tracked by this LIMS initiative. Right. Apart from that, government is also taking efforts to promote alternative dispute resolution mechanism, that is out of the court settlement mechanism. For example, Lok Adalat. The government is also taking efforts to promote this Grama Nyayalaya concept. So all these are also efforts taken by the government to reduce the pendency of cases. Right. But see, now despite of all these efforts, still there is a increased pending cases in Indian judiciary. Right. It is going to increase further also because the population is increasing in one side. India is the fastest growing economy. Soon we will be achieving the developing nation status as per the Prime Minister's ambition. Right. So there is a huge scope for increased litigation in coming days because see, investment is increasing, the commerce is getting increased, people are getting more income, people will be buying more properties. There will be increased litigation. See, increased litigation, that is a good sign because that shows the confidence of people in the Indian judicial system. At the same time, this is going to increase the number of cases. If it is not resolved properly, then the pendency will further increase. So we have to take efforts, additional efforts, right, to tackle these increasing cases. For example, we highlighted the issues. We have to increase the number of judges. We have to address the shortages. Vacancies has to be filled. Right. A permanent court secretaries, court managers should be appointed to tackle the administrative tasks of judiciary. Right. Even the administrative task of judiciary should not fall on the judges. Right. Already they are loaded with so many cases. Now this is going to load them further. So we need to have some permanent secretaries for the courts. Right. At some level it is being implemented, but it has to be completely implemented. Right. And also government should actively promote, create awareness about this alternative dispute resolution, pre-litigation mitigation. Pre-litigation mitigation has to be promoted. We have a lot of such ways like Lok Adalat to solve the issues even before coming to the court. There are many alternative dispute resolution systems. Right. So that has to be promoted. Government has to create awareness. And more importantly, 50% of the cases are with respect to government. Government is one of the litigant. Government should set us an example by going for more alternative dispute resolution mechanism. Government should go for that ADR mechanism. Right. Before asking others to go for ADR, government should go for this ADR mechanism. And also why government is becoming one of the party in the cases. Many a times the government contracts, so government, let's say for example, government and private come with the relationship for executing a project, they come with a contract. There will be some issues in the contract, and that when the issue erupts, the private player will take the government to the court. So the problem comes in the contract. So government should take sufficient efforts to prepare the contract in such a manner there is no issue in the contracts. Right. See, one side government should not make the contract more stringent so that investments will not come. At the same time, government in the contract should not be so lenient. If they are so lenient in future, there will be some issue for the government. Again, it goes to the court. So we need to spend some time. There should be some technical expertise in framing the contracts which government signs with the private players. So government should focus on devising proper contracts, and if at all some issues come, government should choose the ADR mechanism, alternative dispute resolution mechanisms. Right? They should set as an example for others so that we also go for ADR first. Then, if it is not working, we will go to the judiciary. Right? Similarly, we have to strengthen the lower courts with proper technological tools. So, government should spend some money in building the technological infrastructure in the lower courts. Right. At the same time, government can also and judiciary also can come together and focus on improving the number of judges in the courts. We can bring ad hoc judges quickly to resolve the pending cases. Also, the court vacation can be slightly reduced. The court vacation is very, very important. Judges are spending a lot of time, lot of energy in resolving the problems. They need some sufficient break. Without improving the number of judges, without addressing the shortages, we are not recommending to reduce the vacation time. But number of judges has to be increased, shortages has to be addressed, vacancies has to be filled. Once this is done, and also technological tools has to be incorporated. Once this is done, then government, judiciary can consider the trimming up of the vacation period for the courts, so that court can work more and they can resolve the pending cases. And active effort has to be taken by the government to promote this alternative dispute resolution mechanisms. Awareness has to be created. Right. So by addressing all these issues, by improving on the suggested measures, in the coming days, definitely we can reduce the pending number of cases. See, as I already mentioned, population is increasing, commerce is getting multidimensional. We are going to witness an increase in litigations. We are going to see increase in the number of cases in the courts, right? If the above issues are not addressed, then this is going to result in denial of justice. Remember, justice delayed is justice denied. Right, friends? I hope you got some clarity on this topic. So, now based on this discussion, I will give you a question. While increasing the number of judges is essential, it is not sufficient to address the problem of case pendency in Indian courts. Discuss. It is a 10 marker question, so you have to write 150 words. So, plan your answer accordingly. Right, friends? I hope these efforts are adding value in your preparation. I will see you tomorrow with another interesting editorial topic. Till then, bye. Take care.